Arvind, a 4-1 decision. What were the key points which were mentioned by the 4 judge in favor of this decision, and the 1 dissenting judge who used very, very strong words as far as her dissent is concerned?
Ankit, when the Supreme Court transferred all these 58 petitions to the Constitution bench, they also framed almost 9 questions for the Constitution bench to answer all those 9 questions. Usually, whenever a matter is referred to a Constitution bench, then the Constitution bench should look into the legal aspect of it and then should answer those specific questions. That's how 9 questions were framed. That also includes the procedures and rules and also legality of this entire exercise. So that's how 9 questions were framed and sent to refer to the 5-judge bench of the Supreme Court. So the Constitution bench of the Supreme Court, headed by Justice Abdul Nazir, they reframed these 9 questions into 6 questions. And that's where 4 judges have given an affirmative answer to all those 6 questions in favor of the central government. But whereas Justice Nagarathna alone has dissented on very important point, that's on the legality of this entire notification. So this entire demonetization exercise was carried out through a notification that was issued by the Ministry of Finance on November 8. So that's the legal notification based on which the entire demonetization exercise was carried out. Though we all know that Prime Minister gave an address and then he announced the demonetization exercise, but in legal parlance it was done through a notification that was issued by the Ministry of Finance that's dated November 8. So that's the notification that was challenged before the Supreme Court, and that's where the Supreme Court got into the legality of this particular notification. So the very first point, the important argument of the petitioners' side was that as per the RBI Act, if you could see section 26 of the RBI Act, that says that the demonetization exercise can be carried out based on the independent recommendation of the RBI board. That is, the Central Board of the Reserve Bank of India can give a recommendation based on which a demonetization exercise can be carried out. So whereas the petitioners in this case argued that it was not the RBI that independently recommended for this exercise. In fact, according to the petitioners, on November 7th, the Ministry of Finance, that's the Finance Secretary, he wrote a letter to the RBI's governor advising the RBI to recommend for demonetization. So that's why, based on that particular letter, the November 7th letter, the RBI's Central Board met on November 8 and then they recommended this demonetization exercise, and that's where petitioners argued it was not the independent recommendation of the RBI, but whereas Centre initiated a process through this November 7th letter, and that's why they said that this particular notification is per se illegal or unlawful just on this very important ground. That was the first argument. The second argument is that even in the same section of section 26 of the RBI Act, that says that there is a word in that section that says any, wherein the petitioners argued any means it has to be a specific series. All denomination will have several series, like Mahatma Gandhi series, there are several series. So petitioner's argument was that not all the series can be demonetized, only a specific series can be demonetized. That was a second argument. Even that has been negated by the Supreme Court, saying that the word any in section 26 of the RBI Act cannot be given a restrictive meaning that can, even all the series of a particular denomination, let's say the old 1000 currency denomination, all series can be demonetized. So that's an answer that has been given by the Supreme Court. So several such 6 questions were framed. All the 6 questions have been answered affirmative in favor of the centre government by 4 judges. The judgment authored by Justice Gawai on behalf of Justice Abdul Nazir, Justice Bopana and also Justice Ramasubramaniam gave an answer in favor of the government, whereas Justice Nagarathna said because this particular process was initiated by the centre and not by the RBI, that shows that this particular process was in fact initiated by the centre, and that's why she has held this November 8 notification of the Finance Ministry as unlawful.
Right. Arvind, if you also talk about the objectives, the 4 judges who have upheld this decision, they said that there was a link between the objectives that were stated for demonetization and the exercise itself. But they've said that you can't rule down, you can't strike down an entire decision only because of proportionality, and you can't really judge that based on whether those objectives were actually achieved. So what were the major arguments on that objective front? Because the petitioners, one of the petitioners' major arguments was that there was no clear nexus between the stated objectives and the demonetization exercise itself.
Yeah, Priyansh, in fact, that was one other argument, though that was not purely on the legal side of it, but the petitioners made this argument. Was demonetization only the option before the central government in order to meet all these stated objectives? One, black money; second one, fake currency; and also a cashless economy or digital payment system. According to the petitioners, if these are the stated objectives, can demonetization alone be the answer for such stated objectives? That's where the petitioners wanted the Supreme Court to look into this aspect. Is there really a nexus between the stated objective and also this particular exercise? So that was one among the questions that was framed by the Constitution bench, and that has also been answered affirmative in favor of the central government by the Constitution bench, where the Supreme Court has said that there is a nexus between the stated objectives and also this exercise, and they have also said that just based on the test of proportionality alone, this particular exercise or the notification through which this exercise was carried out cannot be held illegal. So that's where the Supreme Court has said that, of course, there is an excess between the stated objective and also this exercise. And that's where the Supreme Court has said that there is no way the court can enter into this domain. Also, very importantly, another important argument of the petitioner was that the 52-day period, the exchange period for which the petitioners argued, that why this 52 days period? That seems unreasonable. That was an argument of the petitioner's side, but that again negated by the Supreme Court, saying that that particular 52 days period for exchange of currency is not unreasonable. That's what the Supreme Court 4 judges have upheld.
You know, Arvind, I just want to ask you, before we, then dissect the nitty-gritties of what has been said by the dissenting judge and, of course, in favor of this exercise, does this mean legally curtain on any questions that were asked as far as the demonetization exercise is concerned? Because a lot of people are talking about whether in terms of the hardships that people went through, in terms of the objectives, whether they were met or not. Does this mean, legally speaking, because politics will be a separate part of this, legally speaking, is it curtains on any legal challenge to the demonetization exercise?
Yeah, and kid, there is no other option left to legally challenge this 2016 exercise, because the matter was referred to the Constitution bench of the Supreme Court, and 6 questions were framed, and Supreme Court has answered all those 6 questions, and they have held, at least in a majority view of 4:1, they have held that there is nothing unreasonable, there is nothing unlawful in the notification that was issued on November 8 for this demonetization exercise. So in all likelihood, it's curtain closed for any legal challenge of this exercise. Even the dissenting judge, Justice Nagarathna, who solely on the legal ground has held that this particular notification is unlawful. But even then, when speaking about the noble objective of this entire exercise, he has said that she is not questioning the objectives of this entire exercise, let it be the eradication of black money or terror funding or to the effect of fake currency, etc. She has not gone into this the noble objectives of this exercise, but purely on the legal ground, because this particular process was initiated by the center based on a November 7th letter and not through an act of parliament, and that's why he has held that this is unlawful, this particular notification is unlawful. But 4 judges have said that it's not unlawful because the center initiated this process 6 months prior to this demonetization. So there were several rounds of consultation between center and RBI, and that's why the 4 judges who are part of the 5-judge Constitution bench refused to strike down this notification that was issued by Finance Ministry on November 8th.